What's up, y'all? We're back again. What's up? Hey, y'all don't make fun of me and my fresh baby face. You know what I'm saying? Don't make fun. I yeah. Anyways, so we're getting back into it. I believe this is part three. We are going through the right to travel in detail. This is the most secured liberties, one of the most secured liberties. We've already read about it in part one. We've read more in part two, and now we are in part three. Let's get right into it. Don't want to be long-winded here with y'all. So let me just make sure that we was on this last one. Pleadings, however, I don't know. I think we were somewhere around here, y'all. I'm not exactly sure. But hopefully we were around somewhere around here. You know what? Let me check real quick. Hold on. Okay. Either way, we're just gonna start from right here. I don't care where it's at. All right. So, a motor vehicle must have been designed for use or to be used to transport persons and property over the public highways. So right off the bat, a motor vehicle has a specific term. There has to be for someone to say you're operating a motor vehicle, you must be using that motor vehicle to transport persons and property over the public highways. If you are not doing so, they cannot say you're operating a motor vehicle. This isn't like a trick. It's all about knowledge. If you know the statutes, then they can't it's all about foolery. It's all about what you know. It is well known by the state and its agencies, that there is an absolute distinction between private travel and commercial travel. When versing a motor vehicle act, hold on one second, y'all. It is critical that the definitions used therein are strictly adhered to. It is further inextricably technical that, in order to enforce the Motor Vehicle Code, the state, by any branch, must adhere to and comply with the whole act rule. Any prosecution, any prosecution, civil or criminal, commenced pursuant to the Motor Vehicle Act must be in fact commercial. Must be in fact commercial. It is the sole obligation of the state to prove that the act in question was in fact commercial. In pleadings, however, especially in criminal, and this is a quote, especially in criminal proceedings, particular care should be exercised in using the proper and correct terms, especially where the definitions to be found in a statute which should be followed in the language of that act. Unquote. Huddy Automobile Law, Ninth Edition. Let's rewind briefly. This is what Hadfield Court said of highway use. Quote, the former is a common right. As to the former, oh yeah, we already read this. This is where I mic dropped last time. As to the former, the ordinary right of the citizen to use the streets in the usual way, your own rights, to travel, the legislative power is confined to regulation. The latter is an extraordinary use. As to the latter, which is the use of the streets as a place of business for private gain, it is plenary and extends even to absolute prohibition, since the use of the streets by a common carrier in the prosecution of its business as such is not a right, but a mere privilege. Because the state may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. Let me ask you this. You think the attorney generals don't already know this? They just don't get it brought up because the people don't know. Caution should be taken when using the term private. When used by the public state, the term private has a business connotation because the public business itself can be either common or private as confidential between two parties. That's why this writer recommends the term personal private in order to distinguish and eliminate any confusion that may arise. The Washington State Supreme Court has long-standing declared the difference of uses of automobiles not inconsistent with the breadth of this document. When taxi operators had their license suspended, they appealed, claiming loss of liberty. The word particular in this exemplar ruling identifies a factual distinction between personal conduct and commerce, and even suggests that one may use a company vehicle for personal use when not commercially engaged. The court said this, quote, the defendants are being prohibited from using a particular mode of travel in a particular way, unquote. State versus Sheffield, or Sheffel. Quote, the evident purpose of the ordinance was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he used a vehicle for his own accommodation. In other words, the ordinance does not purport to regulate or supervise the mechanism of vehicles that are allowed to use the streets. It is only the business of public conveyance of vehicles of some kind that is subject to the supervision of the city. Unquote. State versus Dunkley. In proceedings to punish, this is a quote, for a violation of the regulation, the burden is upon the prosecution to show that the defendant is within the terms of the regulation and has violated it. Do you understand that, y'all? So what that quote is literally saying is that, you know what? Let me see something real quick. So clearly, the state has to prove that you were driving on the commercial, in a commercial capacity. Once it's brought up, they have to prove it. Once it's brought up, they have to prove it. If they can't prove it, the case is closed. And that is City of Chicago versus Gall. City of Chicago really has a lot of good quotes to use in relation to the right of travel as well. So, on the trial of a charge of violating a provision without a license, it is necessary to prove that the accused was plying for hire. As an example, the placement of an automobile on public streets where it is accessible to those who may wish to hire it, and the solicitation of passengers for hire by the one operating it, by word, act, or exhibition of signs or devices. Unquote. Huddy on Automobile, 6th edition, section 149. So, in the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobiles is perfectly legal and lawful. It is only under the auspice of a violation of commercial licensing statute policies that it could be said one has committed a traffic crime. The state would have to act in bad faith to rule personal use of public highways lawful, and then with I hate this word, spurious intent, dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. Quote, crimes are not to be created by inference. They may not be constructed nunc pro tunc. Ordinarily, citizens may not be punished for actions undertaken in good faith reliance upon authoritative assurance that punishment will not attach. As this court said in Raleigh versus Ohio, 360, U.S. 423 and 438, we may not convict a citizen for exercising a privilege which the state clearly had told him was available to him. As Raleigh emphasized, criminal sanctions are not supportable if they are not to be imposed under vague and undefined commands, citing Lanzetta versus New Jersey, or if they are inexplicably contradictory, citing United States versus Cardiff, 344. And certainly not if the government's conduct constitutes active misleading, citing Johnson versus United States, unquote. 16 Am Juris 2D, Constitutional Law, Section 576. So, I mean, right there, y'all, these quotes are your power. These are, again, the Chevron deference has been repealed. They can no longer rely on state, on their own interpretations of the law. They have to go back to the federal interpretations. Of special note here, it is that legislative policy has the blessing of the judiciary. The judicial blessings are supportive that the legislative policy is and only commercial in nature. This leaves only the executive branch of government to be reined and bridled as to their enforcement of interpretation, presumption, or interpretive presumption. Again, Chevron deference has been repealed, noting, of course, the executive does not have authority to interpret statutes. Neither can they presume the statute to mean anything more or less than its intent. Again, the Chevron deference has been repealed. This is amazing. Now watch this. This is pretty cool. But anyways, wait. So, the state of Washington wholly concurs with this writer's rendering of statute policy and law. The following is former Attorney General John J. O'Connell's opinion as to the intent and application of the operator and driver's license. Mr. O'Connell, as a former representative of the state of Washington, agrees that all statutes relating to operating and driving are static, as well as confirming that all licenses issued by the Department of Licenses are in fact issued to for hire status, and by use of the Latin legal maxim, expressio unius est exclusio authorities. He acknowledges that no license may issue for personal use of an automobile. Mr. O'Connell's opinion reads as follows. Again, this is an Attorney General of Washington. Above all of you guys, deputies, all of y'all, hold y'all responsible. Okay, so here we go. This is AGO 61-62, number 46, edited for space and content. Quote, the business of operating as a motor carrier or freight for compensation along the highways of this state is a business affected with a public interest. The rapid increase of motor carrier freight traffic and the fact that under the existing law, many motor trucks are not effectively regulated have increased the dangers and hazards on public highways and make it imperative that more complete regulation should be employed to the end that highways may be rendered safer for the use of the general public. RCW 81.80.211 provides, quote, the Commission may adopt rules and regulations relating to the hours of duty of motor carrier drivers and operators. RCW 81.80.290 provides in part, the Commission may, by general order or otherwise, prescribe rules and regulations in conformity with this chapter to carry out the purposes thereof applicable to any and all motor carriers. Outside the confines of Chapter 81.80 RCW, but of prime importance and significance to our consideration of this matter is RCW 81.04.460, providing, and I just want y'all to remember, a lot of the statutes and laws within the states, yes, they're a little bit different, but a lot of them are the same. So a lot of these things can also be found within your revised codes, statutes within your state. You just kind of have to look and do a little bit of research. So, quote, the Commission shall enforce the provisions of this title and all other acts affecting public service companies, the enforcement of which is not specifically vested in some other officer or tribunal, unquote. Thus, addressing ourselves solely to that portion of your question which relates to driver qualifications, we conclude that the Public Service Commission has the authority to both adopt and enforce rules and regulations governing driver qualifications with respect to auto transportation companies and motor freight carriers. By this, we do not mean to imply that such authority includes the power to prescribe conditions precedent to the issuance of motor vehicle operators' license. The general supervision and control of the issuance of vehicle operators' licenses is specifically vested in the Director of Licenses. RCW 46.20.010, however, the Commission may prescribe safety regulations over and above those prerequisite to the issuance of a driver's license with respect to the drivers of auto transportation companies and motor freight carriers. Insofar as your question relates to the authority of the Commission to adopt and enforce rules and regulations governing safety of equipment, a final conclusion at this juncture would be premature without first considering certain provisions of Title 46 RCW. Section 46.80.010, Chapter 12, Laws of 1961, provides in material part, quote, the provisions of this title relating to the certificate of ownership, certificate of license, registration, vehicle license plates, and vehicle operator's license shall be exclusive. Exclusive. Why? Because they're special and extraordinary than your God-given natural right to travel amongst the roads in which you own. In this respect, it is worthy of note that although several provisions of Chapter 81.68 RCW and Chapter 81.80 RCW have been amended at various times since the original enactment and amendment of RCW 46.37.005, the legislature has never seen to fit to amend in any way the particular provisions of RCW 81.68.030 and RCW 81.80.130, which grant the Public Service Commission the authority to regulate the safety of operations of auto transportation companies and freight carriers, respectively. Under these circumstances, we do not feel it can be said that there is a manifest intent upon the part of the legislator to effect a repeal by implication. Under the maxims of expressio unius est exclusio ratorius, it is the uniform rule that the express mention of one thing in a statute implies the exclusion of all others. State ex Rio Port of Seattle versus Department of Public Service. Provisions relating to the same subject matter embodied in different statutes should be harmonized so as to maintain the integrity of both statutes whenever possible. Furthermore, as previously noted, the authority to regulate granted by RCW 46 Supra, and the other provisions of Chapter 46.37 RCW apply to motor vehicles generally. It is well established that general statutes do not repeal a special statute on the same subject, unless the intent to repeal is manifest, and such an intent cannot be implied unless the two acts cannot stand together and effect be given to both. I know this gets confusing, but you gotta just keep following along with me, y'all. You'll get it. Maybe you gotta listen a couple times. In determining whether any particular rule or regulation of the Public Service Commission is in conflict with those of the State Commission on equipment of those set forth in Chapter 46.37 RCW, the test is whether the former permits or licenses that which the latter forbids or prohibits, and vice versa. Bellingham versus Champera. Yet remains for consideration the question of the Public Service Commission's authority to enforce those rules and regulation which it properly adopts. Its authority in this respect is sufficiently prescribed in that portion of RCW 81.04.460 supra, providing, quote, the Commission shall enforce the provisions of this title in all other acts affecting public service companies, the enforcement of which is not specifically vested in some other officer or tribunal. Thanks, John. Police authority. In order to understand police power, it should be understood what police are. When a man hears or thinks of police, his mind sees a public employee, a public servant with a uniform, usually adorned with assorted weaponry. The word police is a conjugal derivative of policy. There are three branches of government: legislative, executive, judicial. The legislative body writes the policy, the executive branch enforces that policy, and the judicial resolves conflicts of policy. Government employees only fall into one of three categories. If the employee is not a member of a judiciary or a member of the legislature, then he is a member of the executive branch, no matter municipal or state or his status. The uniformed armed executive employees that prey upon our common highways are the same executive branch policy enforcers, likened to those that sit behind a desk and issue tax warrants or demands for child support payments or issue building permits. You hear that? They're the same. They're the same. They're the same. So when you go into there and you talk to those people who issue building permits, are you understanding? Or those people for child support payments, or those people who issue tax warrants or demands, those people in those offices, you know they're on the same level as police? You understand that? The truth of the matter is that if one applies for and receives a driver's license, that creates an assumption that one is always engaged in driving. Driving is legally defined as a person in an actual physical control of a motor vehicle, as an occupation or business. Don't forget the underlying criteria of being paid for services rendered. And that's what the cops never learn. And if they never teach it, well, it makes you really wonder. It really makes you wonder. If they've never been taught it, then there's more at fault in relation to your civil suit. You see what I'm saying? So it's like, when we come into a civil suit, can we now, in all actuality, start going after not only the direct employee in his own personal capacity? Do we also go after his supervisor? Do we also go after his chief? Do we also go after the police department? And then do we also start requesting information to figure out what training facility trained these police officers? And then go after them for not properly training these police officers in the first place? It's food for thought. Because if there's improper training and it's not within their training manual, then they are intentionally and knowingly misleading in relation to their education upon the people coming in to be public servants of us. Yo, man, there's a lot there to unfold. And to be honest with you, I've never done this in civil court, so I can't speak on it myself. But this would possibly be something that I could persuade the Supreme Court to think about and maybe bring something precedent. And we may be able to do this here soon with Luis. So, quote, the police power is exercised for the promotion of the public welfare by means of regulation of dangerous or potentially dangerous business, occupations, or activities. Well, I don't think that if someone doesn't have a driver's license or if someone has private plates on their vehicle, that makes them dangerous or even potentially dangerous at all. Their activities do not show it whatsoever. So let's continue. Now, the state, resting upon their original basis of sovereignty, the state, resting upon their original basis of sovereignty, exercise their police powers and regulates its domestic commerce and contracts. Wow. Right there, bold and plain for you, that everything is based on commerce and contracts. And this is Thurlow versus Massachusetts. This might be a good read, y'all. So, the state only has authority to license and regulate business. Look at there, y'all. They do not have authority over you, the individual. I mean, it's like people be like, but what, we need this and we need that, and I've been taught this. It's like, yo, I'm sorry what you've been led to believe, but the facts are here within the law. It just takes one to be educated enough. Business is commerce. Commerce is the sale and purchase, bought and sold, with, of course, the static delivery, shipment. The driver's license issued after 1968 is, in fact, a proprietary operator license with a secondary driver aspect. This can be identified at RCW 46.01.04013. That's why and how the policy enforcement employees are able to randomly interfere with the public at large through lack of notice and policy that is so deliriously fragmented that a man of average intelligence could not understand it to be anything other than what it is what it is on its face value. Now, I want to read this one again, okay? And I want to do a dummy form on this, so give me 1 second. Okay, so here we go. This is the breakdown into a simple and easy to understand points. Uh-oh. Okay. Easy and understand. Okay, so here's the quote that we just read. Simplified explanation. 1. State's limited power. What the state can do. The government can only issue license and set rules for businesses. What is a business? Business involves buying, selling, and delivering goods or services. Commerce. 2. Driver's license as a business license. Post 1968. Driver's licenses. After 1968, a driver's license is not just a permission to drive. It's treated as a business license. Implication. This means driving is seen as a commercial activity, a business, rather than just a personal right. How the state enforces rules, regulation, and interference. Because a driver's license is a business license, state officials can impose various rules and regulations on drivers. The laws are so complicated and fragmented that most people find them hard to understand. This confusion allows officials to enforce rules randomly without clear guidelines, making it seem like they have more power than they actually do. Power of the people. People's rights. Despite the state's regulations, individuals, the people, retain their inherent rights. State's authority is limited. The government can regulate business activities like driving for profit, but cannot take away your basic constitutional rights. Awareness. Understanding that a driver's license is a business license helps people realize that their personal freedoms are not surrendered to the state. RCW is a law that gives the State Department authority over motor vehicle laws, which don't pertain to you. Section 13 specifically talks about operators' license, defining them under Chapter 46. Effect. This legal framework allows for the state to regulate driving as a business activity. Key takeaways. State's rules limited to business regulation. The government can only license and regulate businesses, including driving as a commercial activity. Driver's license equals business license. Since 1968, your driver's license is a business license, meaning driving is treated as a commercial enterprise. Confusing regulations benefit the state. Complex and unclear laws let state officials enforce rules more freely, sometimes interfering with people without clear reasons. People retain their rights. Even though the state regulates business activities, your fundamental rights remain intact. The state cannot take away your basic freedoms. Stay informed and empowered. Even simpler terms, it says. Government's job. The government can set rules for business, including driving, if you're doing it for money. Driver's license. It's like a business permit, not just a personal ID. Why it matters. Because of this, officials can make and enforce many rules, sometimes in confusing ways. Your power. You still keep your basic rights. The government can't take away your personal freedoms just because they regulate driving as a business. Be aware. Understanding this helps you know when your rights are being respected and when you might need to stand up against unnecessary regulations. Connecting power of the people. Empowerment through knowledge. Knowing the true nature of your driver's license and the limits of government power empowers you to advocate for your rights. Recognizing that the state's power is confined to business regulations help you push back against overreach. Your inherent rights remain protected, and staying informed ensures the government respects those boundaries. So again, if we're doing, maybe I need to write a book called The Right to Travel for Dummies. I mean, come on, guys. This is, yo. Hello? Are you getting it now? Are your eyes open? Okay. So, everybody tells me that I'm dumb, I'm crazy, that the police power and the state has the police power to regulate. They just don't understand the law. They don't study. They go off and they listen to somebody on YouTube. Oh, I guess I'm that guy. But they go and listen to somebody on YouTube just talk, right? Or read an article. But those people that talk and read an article, they don't come and read the law. I read the law. Okay, and yes, I have an interpretation, but my interpretation is based off the law. Okay? So let's keep going. RCW 46.01.040 powers, duties, and functions relating to motor vehicle laws vested in department. Operator's license as provided in Chapter 46.20 RCW. Later in this discussed the state of Washington's spurious introversion of operator and driver, but do not mistake the illusion that a license is not, in fact, permission to operate a business. The constitutional right of every person to pursue a business, occupation, or profession as a paramount right is subject to government regulation and restriction, and as such is subject to reasonable use of police power. If a business itself is a proper subject of police regulation, so are all its incidents and accessories, such as the manner of conducting the business. Unquote. 16A Am Juris 2D Constitutional Law, Section 372. Since it is a universal rule that every business or occupation itself is subject to proper police regulation for the public interest, it logically follows that the right of every person to pursue a business, occupation, or profession is subject to the paramount right of the government as a part of police power to impose such restrictions and regulations as the protection of the public may require. Unquote. Fraser versus Shelton. And this one's, and see also Anthony versus Texas. Oh, so even in Texas. So, to the people I love that were talking about police powers, well, there's your answer right there for somebody who's above you. So you can't refute what they say. You may believe different. You may have different opinions, but your opinions, I'm sorry, man, they really hold no weight because you're not at the top in relation to our public servants. And when I say they're above us, earlier in my part 2, when I was talking about, hey, man, the Supreme Court, they're above us. What I mean is that, like, if we're in that aspect of being a public servant, they would be above us. We're above everything no matter what. But they're above everybody else in public service aspect, right? So, as stated above at Am Juris Section 372, again are the words incident followed by manner. Incident followed by manner. In this context, the actual commission of driving a passenger is incidental to the operation of the business. Likewise, it is well established that the operation of a business and the driving of an automobile are two absolutely distinct actions until the automobile becomes the business. This is where the restrictive nature of a license comes to bear. The license, which is required, restricts businesses' use as well as types of businesses and the incidentals, load capacities, nighttime driving, chemical containers, explosives, and oversized vehicles, to name a few. These things may be prohibited. And this is why we had to initiate all of the laws for our roads, because we ain't out here just transporting all kinds of goods, damaging goods, sometimes poisonous goods. So, I mean, we had to put in regulations because of those things. Not against us, but against those who are using the roads to transport those types of things, because things can be very dangerous. These types of motor vehicles are categorized, and the drivers thereof are classified. See RCW 46.25.080. It is, however, with no small measure of deference that the definition of private carrier is again fragmented and encrypted in yet another title of the statutes as to what exactly is intended by the phrase use of highways for gain. RCW 81.80.010. Section 6A, quote, a private carrier is a person who transports by his or her own motor vehicle with or without compensation, property which is owned or is being bought or sold by the person, or property where the person is the seller, purchaser, leasee, or bailee, and the transportation is incidental to and in furtherance of some other primary business conducted by the person in good faith. The highways of a state are public property, the primary and preferred use of which is for private purposes. Their use for purposes of gain may be generally prohibited by legislature. Again, the distinction between the two, Stevenson versus Benford. Under its inherent police powers, the state has the right to regulate any and all kinds of businesses in order to protect the public. Under its inherent police powers. Okay? So, under the state's police powers, it has the right, and only the right, to regulate any and all kinds of businesses. It doesn't say people. It doesn't say motor vehicles on the highways, any and all motor vehicles on the highways. It says businesses. What don't y'all understand about that? Chief, sheriffs, all of you people who, when we call on the phone and we tell you, and we ask you, and you lie to us and tell us lies, bro, I'm recording every phone call from now on. And when you tell me a lie, any of the public servants, I'm not out against you, but I'm telling you right now, any of you that lie, or any of you that say that you don't know, again, ignorance of the law is no excuse. You don't give it to us. You don't say, hey, well, I guess you didn't know about that with my, like my boy with Luis right now. Luis, well, I guess, just because you didn't know, we're taking you to jail. No, that we're not playing with it no more, man. Y'all need to stop. We coming after it. People waking up. We are in the age of enlightenment, of intelligence. Intelligence is at the fingertips of all now. At a high degree. I, you, and everybody else, if you want and have the knowledge to do so, or find out how to do so, you literally have a team of legal scholars and professionals at your fingertips through AI now. It's all there, y'all. It's all there. You want even a deeper one? LexisNexis has a whole law AI program that you can pay for. And it is amazing. Still sick, man. All right, let's go. Under its inherent police powers, the state has the right to regulate any and all kinds of businesses. Not you and me, but businesses. In order to protect the public health, morals, welfare of its people. You and me. Subject to the restrictions of reasonable classification. Allender versus City of Homewood. As shown above, where the intent of a statute or the execution of a statute must be determined by referring to other parts of the statute or a separate statute altogether, one must invoke the whole act rule, as the separate chapters and separate statutes must be read in para materia. The plain meaning of a statute may be discerned from all that the legislature has said in the statute and related statutes which disclose legislative intent about the provision in question, unquote. Department of Ecology versus Campbell and Gwynn, LLC. 146. We emphasize that we read the plain language of the statute as a whole and interpret its provisions in harmony with other statutes in the same chapter and related chapters, unquote. Miller versus Weaver, 2003. The state nonetheless is endowed with the authority to suspend or revoke a license for careless or negligent operation. However, as clarified earlier and hereunder, the loss of a license to operate a business does not disable a man's use of the same, if appropriate, automobile for his personal affairs. In the Sheffield case, the court reasons a particular use in the particular way, which is prohibited. The Sheffield court, not inconsistent with the Stevenson court, have each succinctly denominated the separate and distinct nature of operating and driving for hire as against the personal use of an automobile. Quote, revocation of a motor vehicle operator's permit is within the ambit of the state's police power to protect the public from reckless or negligent operators. Reckless or negligent. What I find interesting, sorry, I'm coming outside of this quote. What I find interesting here is it says reckless or negligent. The reckless would be endangering people, but what would the negligent go for? Not having your papers in order, suspension and stuff. I don't know. Going back to the quote, the governmental interest involved is that the protection of the individuals who use the highways. Protection of the individuals. The Act, RCW 46.65, calls for the revocation of the privilege of operating a motor vehicle where one has demonstrated his disregard for the traffic safety of others. And only then. So it really is only demonstrated upon his disregard for the safety of others, not in relation to the aspect of proper paperwork. Interesting. Continuing on with the quote, the defendants are being prohibited from using a particular mode of travel in a particular way. Unquote. State versus Sheffield, 82. Let's continue on. The object and purpose of this statute is to promote the safety of those traveling the public highways. Your job is to protect us, not to bring harm to us. The statute has, in effect, forbade the operations of persons under the age of 18. It, in substance, declares that such persons do not possess the requisite care and judgment to run motor vehicles on the public highways. Unquote. Huddy on Automobiles, 6th edition, section 222. When speaking of motor vehicles in interstate commerce, the state must follow federal standards at minimum, as outlined in the U.S. Code and those outlined in the Code of Federal Regulation. These federal standards explain the minimal basis for what is commerce, whether intrastate, or interstate. So while the federal statutes control interstate commerce, they have no authority to interfere or regulate intrastate commerce, insofar as the intrastate commerce does not cross state lines. See also generally 49 U.S.C. 30103 for comity of regulations. Quote, a state may be preempted from establishing its own standards. It is not preempted from enforcing the federal standards, unquote. Sims versus State of Florida. But very different considerations apply to the internal commerce or domestic trade of the streets, unquote. United States versus Best. Under its police powers, the state may control generally the operation of motor vehicles upon a public highway. That's it, unquote. Cohen versus City of Hartfield. The definition of motor vehicle is nearly succinct with the definition of vehicle at both state and federal levels. See definitions. Although the state definitions may be fragmented and diffuse, they operate with the same intent to regulate commercial activity at the state level. By their language, they are intended to regulate commerce and transportation for compensation or the transmission of credit upon the receipt and delivery of property obtained as the result of a transaction. Notice that the state definition is nearly exact to federal, save the deletion of a term commerce. Transportation is defined as, quote, the removal of goods or persons from one place to another by a carrier, unquote. Interstate commerce versus Brimson. Here again, notice that the definition incorporating the term carrier refers to one conducting business. No mention is made of one who is traveling in his personal property. Automobile. This definition is of one who is engaged in the passing of a commodity or goods in exchange for money, i.e. vehicles for hire. Furthermore, the words traffic and travel must have different meanings, which the courts recognize. The difference is recognized in Ex parte Dickey, superstating, quote, in addition to this, cabs, hackney, coaches, omnibuses, taxicabs, and hacks, when unnecessarily numerous, interfere with the ordinary traffic and travel and obstruct them. Interstate commerce, versus Brimson, above. The court, by using both terms, signifies its recognition of a distinction between the two. But what was the distinction? We have already defined both terms, but to clear up any doubt, for all the dummies, let's do it. Quote, the word traffic is manifestly used here in secondary sense, and has reference to the business of transportation, rather than its primary meaning of interchange of commodities, unquote. Allen versus City of Bellingham. So here, the Supreme Court of the state of Washington has defined the word traffic in either its primary or secondary sense in reference to business and not mere travel. So it is clear that the term traffic is business related and therefore it is a privilege. Nobody is disputing that. The net result being that traffic is brought under the police power of the legislation. The term has no application to one who is not using the roads as a place of business. Quote, traffic thereon, is to some extent destructive. Therefore, the prevention of unnecessary duplication of auto transportation service will lengthen the life of the highways or reduce the cost of maintenance. The revenue derived by the state will also tend toward the public welfare by producing, at the expense of those operating for private gain, some small part of the cost of repairing the wear, unquote. Northern Pacific Railroad Co. versus Schoenfeld. Now, all those people who sat here and told me, man, that, hey, man, they didn't do this because people were damaging the roads, and they didn't start imposing taxes and regulations on the commercials because they needed, bro, there it is. There it is for you. We're gonna stop there. No, I'm gonna state one more. I'm gonna read one more thing. We're gonna end off on this page here. In the above case, the word traffic is used in conjunction with the unnecessary auto transportation service, or in other words, vehicles for hire. So this is going to conclude part 3. I know that you know now, deep down within your heart, that you can stand on it. And if it's violated, you know in your heart, deep down, that you have a real case. Now, we've went over something in here earlier that I did not touch base on, which was notice. There was a section up in here where, and you'll see it if you've been watching this, you heard it. I know. If you're not, maybe you got to listen again. This one's not too long. It's about 40 minutes. But they said, if you are not giving notice, you got to put these agencies on notice, man. You got to put these agencies on notice. And that's why I show in the Right to Travel course how to put these agencies on notice with a notice of liability. You have to have that notice of liability notarized, but I teach you how to do it. It's all in the Right to Travel course. The playlist is on my channel, okay? Make sure y'all like. Make sure you subscribe. It helps the algorithm. Again, the Right to Travel course is free. It's in the description. Also, of course, I've now wrote my first book, The Last Tread. Of course, my pen name's James Bullock. And then also in the description is the traffic law reform campaign and petition that I'm asking you to sign. All it takes is a signature. You click on the link, you sign it, you put your name in. That's it, y'all. Because we're sending this off to attorney generals. We're sending them off to representatives, both Congress and senators. We are really pushing for this change so that we can stop the unnecessary revenue generation and theft of property that is currently happening on our roads here in America. I love all of you and I care all for you. And I want you, if you want to be part of this, to reach out to me. I'm ready to start traveling all over the world and talking with people on podcasts. I'm ready to do whatever I possibly can. If you have anybody anywhere, I will travel anywhere and speak on this to bring this forth. I appreciate all of you. I love you all. Till next time, till part 4. We'll see you on the next one.